Viewers, welcome to my live show Legal Hours with Suhel. I'll be with you next couple of minutes to give you some important update. I'll speak a couple of points today, including EU law, Zambrano right, as well as some fee waiver application. Whether EU nationals can still apply to bring their family member to come to the UK. The parents of British child or any carer of an adult citizen who are on 10-year route, they can apply under 5 years route under the EU settlement scheme. So a couple of questions. Let me start with Zambrano carer. Zambrano carer, we are end of the deadline because as we know that if you are a parent or carer of a British child, or if you are a carer of an adult British citizen, you can apply a leave to remain on the basis of Zambrano carer under EU settlement scheme. As you know, EU settlement scheme deadline has expired 30 June. However, it was extended for 6 weeks from 1st July. So next, after 2 weeks, it will expire. So I invite you, if you are parents of a British child, or if you are providing care to an adult British citizen, please make an application to under EU settlement scheme. And if you are lucky, you will get settled or pre-settled status under the EU settlement scheme, like the EU nationals and their family member get pre-settled or settled status, which is a very easier route. Although I said deadline extended for 6 weeks from 1st of July, already 4 weeks has gone, nearly 4 weeks has gone, and maybe 2.5 weeks left. Even if you make the application within that deadline, there is a possibility if the Home Office loses the appeal, Court of Appeal, then you will get pre-settled or settled status. The advantage of Zambrano carer or carer of a British citizen, a lot of advantage. The first advantage, I would say, that you will get 5 years visa, and after 5 years you will get ILR if you just make the application. If you are already spent 5 years as a carer, or if you are on 10 years route and spend already 5 years, right now straight away you will get indefinite leave to remain. So this is the advantage of this application. Now, what are the chances to that application will be success? Well, this application we are advising for many people to make this application based on a decision of the High Court. The High Court said the carer of British child or British citizen can apply under EU settlement scheme irrespective of their status or their relationship with the British citizen. That was a consent order. However, the Home Office appeal against the decision of the High Court to the Court of Appeal. We are expecting that the decision of the Court of Appeal will come next month. But what we also expecting that Home Office will success in the appeal, and then if Home Office lose the appeal, if the Court of Appeal doesn't overturn the decision of the High Court, then all the people who will establish the relationship with a British citizen as a carer, they will receive pre-settled or settled status. Now look into it. If you apply for settled status, so if you apply for normal immigration rules rather than EU route, you need to wait for 10 years to get ILR. Every 2.5 years, you need to pay Home Office fee, you need to pay NHS fee, and a lot of requirement you need to fulfill. And 10 years, you need to carry on this burden. And after that, you need to pass Life in the UK test, you need to pass English language test, and then you'll get ILR. But if you are eligible for EU settlement scheme, if you make an application and if the application is successful, you don't need to do that. You will get your ILR. You will get just 5 years. Some people will get right now ILR. Some people will get ILR after 2 years or 3 years. It depends on how many years already you spend as a carer of a British child. This application is very straightforward, so I'll tell you how you can make the application. Although it is very straightforward application, but it is very technical. You need to establish that you are the carer. If you just establish you are a mother or father of a British child, it will not work. Only carer. But the principle is that if that carer required to leave the UK, then the child also has to require to leave the UK or chances to move in any non-EU country or EU country with the father, with the mother, because the child or the British citizen is rely on the carer. That was the main principle is. So you need to be a carer of British child. So how can you establish a care? This is the main essence, main policy, main theme of this judgment. Now, how you can establish that you are a carer? Now, you are carer is very basic common sense. You provide that to care. You change the napkin. You take the child to GP. You take the child to school. You attend the parental meeting. These are the evidence you need to provide. So the guidelines said you need to provide evidence that you are the carer. So you can give a letter from the GP that you are the person in primary contract. So your mobile number, your details as a parent or as a carer at the GP record, they will write a letter to you. That's one evidence. Another evidence can you get from the school, although school are closed because it's the holiday time, but still you can make the application. You can give the document later. So what you can do, you can get a letter from the school that you are the carer, you providing care to the child. You take the child to the school, you attend the parental meeting. So school will give you a letter that you collect him, you take him to school, you attend the primary meeting. That will provide evidence of that you are a carer. Now, these are the two main evidence, GP letter and the letter from the school. In addition to that, you need to establish how many years you are providing, because if you want to apply for ILR, then you need to provide 5 years document. Now, there is a list of document which we provide. We ask the applicant to give us so that we can make the application. Now I'll tell you how to make the application. It is not necessary that you need to give all the document right now with the application. So you can fill up the application form, although the form is very technical. I would say if you are not competent, go to a solicitor, make the application. Don't go into, because there are some technicality, because this application is not based on immigration rules, it's based on a case law, and you need to reflect the judgment, the direction of in your application. For example, if you claim as a joint carer, right, then the Home Office say, well, child doesn't need to leave the UK because other British parent can provide the carer. So you need to provide evidence. No, the child is dependent on me, not the other father who is a British citizen, and you need to provide evidence. So it's very technical. So don't just make the application. Speak to a lawyer. Although you don't have much time, limited time, but still you can manage to get a lawyer who knows, because a lot of people even doesn't know about this case, because this was very limited period, because people get chance to make this application within 6 weeks, from 1st July to 6 weeks, when it comes to the middle of the August. So many people within this time are not aware about this case. Many client doesn't know, many professional doesn't know. So you have to go to that professional who know about this case. So now how to make the application? You need to fill up the application, submit it to, you can send, it used to be send it by email, but now the email you cannot send it anymore, because the email what we used to send is full. The email is full. They are not accepting any more applications. So you need to send it by post. So you can send it by email or post, but you cannot email it now. So you need to post it. You need to download the form, fill up it by hands or in computer, and then print it and then send it to the Home Office. Now, once you send it, from that date, within 10 days, you need to submit supporting document. But many people will not able to send the supporting document because of the school closed. GP is not seeing the patients face to face. So because of the difficulty, I think you can send the document later. So after 10 days, within the 10 days, whatever you have, send it by post, or you can send it at a time. And after that, you can send the rest of the document when you receive it. So this is how the application you can make. The good news is you don't need to pay any Home Office fee for this application. You don't need to pay any NHS fee for this application. This application is free of charge. So if you are lucky enough, you will get ILR directly right now, rather than wait another 10 years or 5 years. So please make the application as soon as possible if you are, because we don't have much time, only around 2.5 weeks left. If you need any help, you can contact with us. The contact details appear on the screen. I will show you. This is my contact number, our office number. If you need any help or if you need any information, you can give us a ring and someone will able to provide any information. Let me move on the other issue about EU nationals and Brexit. Now the question is, UK already left the European country, can EU citizen apply their family member to come to the UK despite we are out of the EU, we are out of the transitional period, we out of the deadline? The answer is yes. Still EU nationals who in the UK who has pre-settled status, who moved in the UK before 30 December 2020, received the pre-settled status later or before, and their relationship established before 31 December 2020, you still can apply to bring your parents, to bring your children, to bring your wives and your close family member. Only difference is you cannot apply for your extended family member, but you can still apply for your first close family member to bring them. So if you want to bring your parents, still you have time to apply. But again, there are a lot of more difference. The application was made before 31st December and after 31st December. So the main difference is, for example, now you need to establish that your parents is dependent on you. So you need to provide bank statement. You need to provide money receipt that you're sending money, a reasonable period of time and a reasonable amount of time. Now, one technical issue you need to remember, although Home Office shouldn't refuse, but from my experience, I see sometimes, especially from Pakistan, Bangladesh, India, and some African country, when the people apply for their parents, the Home Office refused it on the ground that they are not dependent on you, and the amount of money you send. Sometimes they argue that the amount of money you send to your parents is not enough to maintain herself. That means she is dependent on somewhere else, someone else, or on her own. But it has to be established that she is fully dependent. So what we do when we make the application, we bring a basic standard living cost in the particular country. For example, Bangladesh, £20,000 or £10,000. We collect the information from the different survey, and then we send the Home Office that amount, £100 or £50 is sufficient to maintain someone on back home. Therefore, she is fully dependent on him. So these are the technical area I think you should deal with in your application. If you just make an application, or a lot of people make, those unprofessional people make the application by £100 or £200, trust me, if you are lucky, you'll get, but there is more chance that they will refuse the application. And once they refuse, it is very difficult to get visa subsequently. So if you want to invite your family member to come to the UK, make sure you make the application correctly, deal with all the technical matter, because after the Brexit is very important to deal all this matter, because it's not an automatic right. You need to establish, you need to satisfy the legal requirement. But the main point is still you can apply for your family member to come to the UK. Family member means close family member, means your parents, your ascendant line, descendant line, your grandchildren you can bring, your granddad you can bring, your grandfather, grandmother you can bring, great grandfather you can bring, your grandchildren you can bring, your great grandchildren bring, because close family member cover the ascendant line and descendant line. Next, move to UK border bills. UK border bills about regarding the asylum, those who want to seek asylum in the UK. Unfortunately, not a good time. So what the Home Office introduced, the Home Secretary Priti Patel last week introduced the UK border bills. The main point from this border bill, what is more concerning as a lawyer, as a human rights lawyer, is if anyone come to the UK by a route which is not a usual route, and he seek asylum, the Home Office consider this is a crime, and they, rather than take you to detention center or take you to hotel to provide a better accommodation, they could take you in prison, because this is a criminal offense. So this is the main issue, what is very important and very concerning. Already the in the House of Commons, the Westminster second reading already done. More probably next round will be pass the law and then incorporated law, because Conservative is more likely this border bill will be low. So what are the changes? Now the changes is other concerning area, that if someone come to the UK seek asylum, the Home Office will look into it whether he traveled through any safe country, and whether he had any opportunity to seek asylum over there. If they find he traveled through a safe country, or he had an opportunity to seek asylum any other third country, the Home Office will deport him to that safe third country without considering anything. This is also a second concerning area. So how could that work? Normally, asylum seeker before Brexit, I mean, under the EU law, there was a Dublin Convention. So under the Dublin Convention, they deport the asylum seeker to the France, or any, if someone seek asylum before in Switzerland, or for example in Spain or Italy, they send him back to the over there where he previously was resident and where he was previously seek asylum. So that rules has changed, and now what are the requirement? Now the requirement is, now that they're trying to introduce that because of the Dublin Convention is no more because of the Brexit. So what they're going to do, they're going to send the asylum seeker to anywhere in the world. It's not necessary to send to the member of the Dublin. They can send in Turkey, they can send in Syria, they can send in anywhere, India. So for example, if you travel from Bangladesh, you went to India, then you went to Libya, then you went to Turkey, then you went to Europe, and then you travel to a dinghy to London or anywhere in the UK. They can send you Turkey, they can send you Libya, they can send you in France or anywhere in the Europe where you was. That was the difficulty. Now the problem is, the safe country, the Home Office has not yet sign any agreement with all the world, around the world, all the safe country, like Turkey. They didn't make any sign any deal. I think only Albania they made a deal, and none of the country that yet made a deal, sign any deal. So it is unlikely they will able to deport them to any safe third country until there is an agreement to all these country. But still, this is very concerning. They may be deport him back, but the main concern was the criminal record. They will put you in trouble. They will not provide accommodation. You will be in prison rather than go to detention center or accommodation. I don't know yet, but it's very concerning. Now let me deal with the another things is admissibility rule under paragraph 345. This already in place last year. That is, remove to a safe third country, or this is what I discussed. Now another thing, that designated place of asylum. Now people, when someone come to the UK, they can seek asylum around. They used to seek asylum any place, okay, wherever. For example, if someone arrest in a police station or a raid, police do a raid in a restaurant or in a workplace, they arrest him, he can seek asylum at the spot. But that was going to be abolished. So what now you can seek asylum only at the designated place of asylum. Now the immigration rules define what is the designated place of asylum. These are airport, any port, any designated immigration officer. So there are 6 places of asylum where you can seek asylum. So you cannot seek asylum in police station. You cannot seek asylum in a person who arrests you, or in immigration raid they arrest you, and you can tell the immigration, I want to seek asylum. This is not how it will work. So you can seek asylum only, or if someone come illegal way through a dinghy, they arrest him in the airport, in the Dover, in the border, you cannot seek asylum on the Dover. So that's what going to be changed. So in overall, by the way of introducing immigration rules 345 and the current border bill, make the difficult for asylum seeker who want to seek asylum. Now, what are the other area someone can save himself if he need help because he is escaped from the prosecution from his home country? Because a lot of people coming who are genuine asylum seeker, they face prosecution because of their belief, because of their religion, because of their political view, because of their sexual orientation. And under Article 1 of UN Convention on Human Rights, someone can claim asylum on that basis. So I'll come after a short break about it. Other than asylum, what other route you can use to make your live in the UK? Hello. So, human rights. Now, if your asylum claim failed, or if you cannot, or for example, you are not eligible for asylum because to claim asylum, you have to be a refugee, and your circumstance must be within the ambit of the definition of refugee. And what the definition of refugee is given by the Article 1 of UN Convention on Refugee 1951. So that is, as a definition, you must be fear of, in short, must be fear of persecution of because of your race, religion, political view, or any other reason as defined on the Article 1, and you are unwilling to return to your home country. That was the main refugee. But if you are not in that situation, or if you not qualify as a refugee, you can claim on the basis of humanitarian protection, which is other area. But many people even also don't exercise that road. What is humanitarian protection? You can claim human rights claim. Now, Article 2, Article 3, Article 6, this is the unlawful detention, right to life, prosecution. So these are the area where you can speak to, or you can think into it, whether if you are not eligible for asylum, then whether you can make an application or claim in humanitarian protection, or you can make a claim on the basis of human rights. Many people know about the human rights, that is Article 8, for example. Then Article 2, Article 3, right to life, unlawful detention, prosecution, unlawful torture, forceful torture, these types of other area where you can look into it. But humanitarian protection also an area where many people not aware. So I think if you are not qualified for asylum, maybe you think into whether you are qualified for humanitarian protection. So that was about the border bill and asylum, and then let me talk about another issue. What is now, again, I need to go back to EU law again, as Brexit, because many people fail to apply under application under EU settlement scheme. Many people. The reason some people stuck in Europe, they cannot travel to the UK to make the application under EU settlement scheme. Some people was in the UK, but they don't have access to internet. They don't have any knowledge about the English. They don't have connection with the politics, news. They don't know about it. They just work, come home, or they're ignore about the Brexit and what's going on. Some people was negligent. So these people, for any reason, who missed that deadline, that is 30 June 2021, they failed to make the application. What are they? What can they do now? Now, first of all, the Home Office position is Home Office will assess those who missed the deadline. More likely, they will give them a notice for 28 days to make an application. Okay, this is the one option. Other option is, if you go to an employer to get a job, employer refuses to because you don't have right to work. Those people who missed the deadline, you are overstayed. This is the starting point. So you go to an employer, he says, sorry, you can't offer you a job because you are overstayed. He can refer you to the Home Office, and Home Office will give you 28 days notice. Or other option is, you apply for a benefit, or you have already was in benefit, but the DWP stopped the benefit. DWP will give you or refer you again 28 days notice, and within this time period you can make the application. This is the one option. The second option is, if you fail to make the application for a reasonable ground. What are the reasonable ground? Which is already defined by the Home Office in policy guidelines. For example, for medical reason, for childbirth, or you was in hospital, you was in quarantine, you stuck in Bangladesh, India, Ghana, Nigeria, in Spain, be due to the red list country, right? You cannot travel to the UK. This is also a reasonable ground. So if you can establish you fail to make the application within the deadline for a reasonable ground, you can again apply the EU settlement scheme application for pre-settle or settled status still. You have the time, right? So those who may fail to make the application, whether you was in the UK or outside the UK, still you have time. You can make the application. And I will tell you, Home Office was very reasonable in terms of the requirement of EU settlement scheme. I saw that a lot of people, even they was not qualified, but they grant them pre-settled status just because of the sympathy. And these things, I think Very good. So still you can make the application. If you need any help, you can contact with the Home Office EU Regulation Center, and they will give you a flexible. If you can make the application with all the supporting document, the letter from the hospital or GP, or if you are stuck in red list, can give an explanation by yourself. A print that the government policy that if, for example, India was in red list country, so you can print it that India was in red list, I cannot travel and I cannot make the application. Even though even last minute, for example, if you stuck on June because you had an opportunity to make the application even in end of the June, 30 June, you cannot travel to the UK to make the application. Because of that reason, you can make the application now. Okay, so those who miss the deadline, you can still make the application with a reasonable explanation. You can still apply for your family member to come to the UK. So this is all about. Now, next things I want to discuss about the British citizenship. This was a very exceptional case, automatic British citizenship. Your child may be a British citizen and you don't know about it. Now, Home Office, again, this is kind of in relation to EU law. Home Office introduced a Section 10A, the British Nationality Act 1981. What is this? What's the requirement? What are these? This is what is called automatic British citizenship for children of EU citizen, right? You know, if someone, the requirement to your child will be a British citizen if you have ILR, right? If you are settled in the UK and if your child born, your child will be a British citizen by birth, by automatically if she is British citizen. But what the Home Office introduced Section 10A is your child will be British citizen even though at the time of birth your child you don't had any settled status or indefinite leave to remain, but you was eligible to make the application for settled status, but you didn't. That means you haven't that time, you didn't have the settled status, despite your child was born that time, and subsequently you make the application, you got the ILR later, but your child was born later, you will get ILR. Hello? Right, I'll come back again. So these are the requirement. Now, Section 10A. I hope this information will help. So if your child born before you get settled status, have a look, speak to a lawyer and look into the Section 10A whether you call your child is British citizen. And then I'll move to claiming benefit for asylum seeker in. Okay, no, let me tell about some case law. I'll discuss some case law in next day. So this is I spoke about today the EU citizen and the Zambrano carer right pre-settled status. Now the one important issue also is relevant for EU citizen, the pre-settled status and claiming benefit. Now many citizens who hold the pre-settled status, when you apply for universal credit, pension credit, or any kinds of mean tested benefit, the DWP refusing a benefit. This is very important. I think I should address this now. Straight with the thing is that those who have pre-settled status, and if you are making any claim after 30 December 2020, then home DWP refuse your hold your decision and not paying any benefit, whether it's pension credit, whether it's universal credit, housing benefit. The reason is probably the DWP already wrote to you that pre-settled status holder will not eligible for benefit because there is a case pending in the Court of Appeal, and once the decision comes, we will give you, okay, or will not give you. We'll give you a decision whether you are eligible or not. This is correct because pre-settled status holder, the applicant apply for benefit, and they refuse it, and then appeal, the High Court give decision, and then the DWP appeal against the decision to the Court of Appeal. So this is the status. So until the decision come, they will not. So they keep hold your decision. Once the judgment will come of that case, then they will give you benefit or not. Okay, but if DW failed, if the unsuccessful the appeal, then everyone who applied, all of you will get all your benefit backdated since you apply. Now, why I am addressing this information you already know, but what I am addressing this is the judgment came from the European Court of Justice about the same scenario, and in the case number is C70920 CG, Department of Community in Northern Ireland. And in this case, what the court said, denying benefit to you pre-settled status holder justified if not fundamental right breach. That means if you have a pre-settled status, and if the respected member state refuse, like UK refuse to give you benefit, then this will be justified, okay, unless no fundamental right breach. So what is this, and what the DWP guidelines say? DWP guidelines say almost same thing, but what extra things what you can take into account, you can make the application. If you have just only pre-settled status and you apply for benefit on that basis, Home Office, the DWP will not give current position. They will not give you benefit, right? However, if you have a right to reside on any other basis, in addition to pre-settled status, you are eligible to get benefit. So when you make the application, you need to mention it on what basis you are applying. For example, if you are a Zambrano carer, if you are a carer of a EU child, right? If you are a carer of a British child, right? If you have any other reason, rather than just pre-settled status on the basis of EU law, then you will not get. But if you have any other basis, in that case, you will get benefit. You should. That's what exactly DWP guidelines is. Now, as this decision came from European Court of Justice, more likely same outcome will come from the the case, what is Fatija case in the Court of Appeal. I'm not sure the exactly name. So more likely same outcome come, and unfortunately maybe those who have pre-settled status, they will not get universal credit or other mean tested benefit or pension credit. So what you can do now, your situation is different. If you make the application on the basis of your child, or if you include child, for best interest of your child, DWP should give you benefit. And there policy guideline in place that if you have leave to remain other than pre-settled status, or in addition to pre-settled status, if there any other reason where you can claim leave to remain, you can claim. So best interest of the children, if you have the Zambrano care right to decide. There are also some other cases. Another case is called Ibrahim, another case called Chen. So these are the area where you can have a look, and whether you can think into whether you can claim universal credit or other benefit with in the basis of pre-settled status in addition to other area. So you can speak to a lawyer who is expert on welfare benefit and look into it. Then okay, right. This is all about today. Hopefully I'll speak more about this in future. If you need any help, you can contact with us, contact with our office. This is the contact details of my office. If you need any information, you can make a call to my office, and someone will able to offer you help. The thing is today whole discussion is about law and EU citizen, and the issue relating to facing those who have pre-settled status. Many people fail to make the application within the deadline. Some people also have some other issues. So if you need any help, you can contact with our team, with our office, and then I will provide you some help. Now, a couple of questions came. Let me see. Someone asked. I want to translate to a neighbor who is listening but is not fluent in some of the let me see this one. Hello brother, how long should the child have held the citizenship before qualifying for Zambrano correct? Brother, as soon as your child become British citizen, from that day you are qualified for. I submitted my application 2 months ago, and I have fingerprint 1 month ago. Yes, I understand. Thank you. Congratulations. Maybe you will get your visa, but your question is not here. Then the next question is, how long home office take at the moment for family permit youth settlement scheme? Currently, if family permit taking quite long, to be honest, around 4 months, 4 to 5 months. So you need patient, because there are delay in Liverpool. So unfortunately, you need to wait a little bit. Yeah, thank you. I'll end the meeting today here. If you need any help, please contact to our office, and someone will able to help. Take care, everyone. Please share this message to your timeline if you think it will benefit our community, our brother and sister. This is all is a free of advice. Is just information, sharing information with the communities, sharing information with the people of our community. Please share this video in your timeline so that people can be benefited. Everyone, take care and be safe. Look after your family. Thank you very much. Assalamu alaikum warahmatullah.